For those that are new, I'm Matt Hall. I'm the leader of the House Republicans from the Kalamazoo area. We just got done with a great memorial service in the Senate, Memorial Day service in the Senate. I'm just here today because we're concerned. We're standing here with members of the legislature who have a background in public safety, as well as victims and their families, to talk about a package of legislation that the Democrats have put forward that they call Second Look. And it's very interesting. You know, we've seen a lot of proposals from these Democrats to let people out of jail. There's been discussions about a sentencing commission. You look at these good time credits. We had a hearing this week on a package of bills to let people out of prison before their sentence is over, or before the minimum of their sentence. But, you know, with juvenile lifers, if you look at this, so the juvenile lifers package was heavily criticized. And all that did was give an opportunity to let all these criminals that were juveniles at the time they committed their crime to get out of jail after 10 years. It gave them all that opportunity. Well, what this is allowing any criminal, just about, except for a narrow exception, to potentially get out of jail after 10 years. And I'll let Rep. Filler talk a little bit more about it, but the concern is if you let, for example, in this, there's a very narrow definition of a mass shooter, okay? And you know, with a lot of these prosecutors, they plead these things down. So if it's not this first degree and then it meets all these criteria, that's not a mass shooter. So for example, where I live in Kalamazoo County, this Jason Brian Dalton, who was the Uber shooter, he killed 6 people. He does not fit under the definition of a mass shooter. Okay, therefore, he would be eligible for parole in just a few years, even though he killed 6 people, murdered them. Okay, now under the legislation, everything else, they're eligible after 10 years to get a new get a new sentencing hearing and get out of jail. So, you know, those that attended what was it, the Criminal Justice Committee this week, you know, I heard our local prosecutor in Kalamazoo, Jeff Getting, talk about over the last 10 years, the prison population in our state has declined. I think it was in the 50,000 range 10 years ago. It's down somewhere around, I think he said 33,000, but it's definitely under 35,000. So it's been declining over the last 10 years. All right. And, you know, we passed some criminal justice reform my first term. And so there are things that have been happening. So I know a lot of these people are saying we need to get people out of prison. But the system has been doing that. So I'll just give you an example out of that number that I just gave you, okay? With this second look legislation the Democrats are proposing, right now, 5,140 people that committed first or second degree murder would be eligible for getting out of jail. I mean, those are the worst, first or second degree murderers. 1,760 people who committed criminal sexual conduct would be eligible potentially to get out of prison. So I just told you where that population is in terms of the total prison population for the state. These people have served 10 years or more, would immediately be eligible for one of these hearings. In all, we have over 9,000 criminals that would be eligible out of that population that I mentioned before for parole, okay? So, or would be eligible to get out of jail. Now, remember, many of these people, particularly these murderers, you know, they were probably sentenced to life without parole, a lot of them. Well, this would allow them to get out now. All they would need is one of these hearings. And to take it a little further, which is, you know, why we're talking about this package, why it's so extreme. So you get these people if they have asthma or diabetes or some other condition that they argue they're immune compromised, they get a hearing faster. Okay, they get a hearing faster for that. And in some of these cases, which Graham will talk about, The presumption, so the burden of proof is on the basically the state to explain why these individuals should not be let out of prison. So it's not fair. It's not down the middle. It's actually they have to go and push further to win that argument why they shouldn't be let out of prison. And again, when these people were all sentenced, they were sentenced to a term. Now they could get out early under these provisions, which to me is pretty concerning. So that's why we're talking about this today. We want to raise awareness for this because there are all these different proposals going around about public safety and letting people out early and being fair. But this by far is the most extreme proposal that we've seen from the Democrats yet. So I'll turn it over to our vice chair of the Criminal Justice Committee, Graham Filler, to expand on that.
Thank you, Leader. Thank you. And I did get a call earlier this week from someone, and essentially they said, what the hell is going on in Michigan with these bills? We have an impending public safety crisis on our hands when it comes to very aggressive bills that would let very dangerous individuals out much, much earlier than the justice system has decided that they deserve. And it's being tilted in favor of the criminal and not the victim. And that's not what Michigan wants. So this second look legislation, this is instant access to a rehearing for 5,000 murders in Michigan. It sounds like I'm saying something unrealistic, but that's what's in the bill. And so we just read the bill and we tell it to you. And maybe we wouldn't take it so seriously, but I believe the chair of a committee is one of the main sponsors on the bill. So we have to take it seriously. We have to presume this is coming up for a hearing. The productivity credits says, we told the domestic violence victim, that you can plan your life around 4 years minimum, and that perpetrator who poured boiling water on you, who tried to hurt your children, that you can move to a different town, that you can change your name, get into the address confidentiality program. Well, could be 4 years, it could be 3. They're going to cut massive time off their sentences for taking classes. This legislation is not being fair to Michigan victims of crime and to the law enforcement community who have all come out against this. So we've got a couple individuals who have been through the justice system, not by their own choice, who are going to be speaking today. Nicole, I think I'm going to lead with you if that's all right. And Nicole, I got to know because her ex-husband was sent to prison for, I believe it's aggravated stalking.
Initially it was aggravated stalking, second offense.
Okay. And then while the individual was in prison, tried to hire multiple people to kill her and her family. And due to the attorney general and some prosecutors who really got in there to protect her, he was resentenced to, I believe, 13 to 30 years in prison for hiring someone to kill her. He would have instant access to being let out of prison. And I don't think I would stand for that. And I think Nicole will speak to that. And she's become quite a wonderful figure in the victim in Michigan and really nationwide, speaking about her experiences. So, Nicole, if you would.
I'd like to lead with just stating that I am not against individuals who are incarcerated getting rehabilitative services. I have loved ones who have gone through the incarceration system, and I by no means am saying I do not feel like they deserve rehabilitative services, and for lesser crimes, of course, the ability to earn time off of their sentences. However, these bills pose a danger. They are a direct threat to victims of many crimes, not just domestic violence. But because I work primarily with victims of domestic violence, I'm a survivor of domestic violence and stalking, and in multiple attempts by my ex-husband to hire people to kill me and my children from prison. I'm going to speak probably most passionately about those issues. These bills, many of them are being portrayed as victims' rights bills. And victims are not being told the entire truth about what these bills actually mean. And when you'll hear some other advocates speak, when we ask victims who are saying they support this bill what this bill really means, they don't know the truth. That this means that their perpetrator has an opportunity to get out much, much sooner, and before they have time to prepare and find safety. So I'm an individual right now. I have until 2030 with Truth in Sentencing to change my name, change my social security number without any assistance. There's no assistance for victims doing these things. This is on me to do these things. When I do that, I lose my master's degree in clinical social work. I lose every minute of work experience that I've put in over, the last 30 years of my life. And I will have to go into hiding and I will become a new person. But right now, I know I have until 2030. Should these bills pass, I might have until 3 years from now. I might have until 4 years from now. I might have until 8 years from now. I don't know how much time I will have. And that disrupts my entire life and the entire life of my children. And I'm not the only one that will be impacted by this legislation. I also want to make it clear, one of the things that I keep hearing people saying is people are going to get out anyway. Don't we want them to have rehabilitation opportunities? The reality for domestic violence is people do not even face incarceration until at least the third conviction. Domestic violence does not become a felony crime until you have been convicted at least 3 times, which means in reality, it's more like you've been convicted of domestic violence 6, 7, 8 times because they are repeatedly pled down to second degree offenses and they remain misdemeanors. Sorry. So ultimately, these people have been given 1, 2, 3, 4, 5, 6 chances and opportunities already to be rehabilitated, to go through offender programs that they've been sentenced to by judges. They are given this opportunity and they keep re-offending. Recidivism for domestic violence and stalking rates is probably one of the highest crimes you will see repeated and repeated. So saying that, rehabilitative services are going to work when it comes to domestic violence and stalking is a lie. It's a lie. If we look at data, if we look at research, it will show up everywhere we look. So I just want to be very clear that that excuse that I keep hearing over and over again, that, they're going to be rehabilitated and just get out anyway, is not true. The last thing that I really want to address is I know the parole board and people's confidence in the parole board. And I think people don't understand unless you've lived through it. It is not like you see on TV. It is not like you see in the movies. Our Michigan parole board is one person that you meet with. The perpetrator meets with one person. That is who decides your fate. It's not a committee of 6 or 7 or 8 people who are collaboratively looking at the situation and making a decision in your best interest. It is one individual interviewing the perpetrator. If they do not are in agreement, then it goes to their supervisor. Otherwise, 2 people hold your fate in their hands. And my ex-husband was approved for parole after he had already attempted to hire one individual to kill me from prison, after he had 3 weapons charges in prison, after he had 13 misconduct charges between jail and prison. So clearly the fact, and I am blessed because inmates came forward after he was approved for parole and stated that he was trying to hire them to kill me and my children from prison. Had they not stepped forward, I would not be standing here before you today because I would either be dead or I would be living somewhere else under an alias. So I'm passionate about these bills and I am willing to talk to anyone further about this. And I'm going to step off the mic now and allow someone else an opportunity to speak. Thank you.
Thank you, Nicole. Did you mention the movie?
I did not.
I mean, you almost can't make some of this up. Where her story that I think they turned into a movie called Finding Nicole because the individual who was in prison, the perpetrator, tried to find her and hire to have her killed. And it does sound like a movie, but it's real life, unfortunately. So, Karen, if you would. Karen was here, was it a week ago, 2 weeks ago, speaking against the juvenile life without parole bills that would have allowed somebody like an Ethan Crumbly from Oxford to possibly be paroled 10 years after conviction, and that was just for juveniles. She's now seen the second look legislation, and which goes much further for many more individuals. And so she also runs a website called or a Facebook page, Voices of Murder Victims. And I think one thing that we would all agree, which is victims didn't choose this, and they don't want to be here on a Thursday, but somebody's got to speak up. And so she's been a great voice for individuals. She's been talking to committee members one by one and just trying to inform them about what these bills actually do. You know, sometimes in the legislature, folks don't know what they're voting on. Might shock you, but these bills have a lot of things in it, and I don't like them, and I don't think she does either. So please, if you would.
Thank you. Again, I'm Karen Jackson, and I represent a group called Voices of Murder Victims. It's a Facebook group made up primarily of friends and family co-victims of murder. Of course, the real victims are not here and do not have voices. I'm sure they would love to express them right now. This was sort of a surprise to me when Representative Filler, thank you, announced the press conference. I thought we were going to primarily be talking about the productivity credits, which I have an issue with. But the second look, second chances, I found very disturbing. And I'm going to tell you right now, I am having a panic attack right in front of you, because this is what happens to us co-victims. We're constantly slapped in the face with proposals for leniency for violent criminals. We're re-traumatized. We don't understand, just as we try to get our feet straight, how this keeps happening. The focus seems to be on the offenders, making their lives better, all at the cost to us. We know one thing. There's no guarantee, no matter what kind of rehabilitation that takes place or what kind of credits an offender receives, that they're going to come out and behave themselves. You know, I'm not an attorney and I don't understand the law, but I do understand the common sense of a parole board, or as Nicole said, one person does not have the training or expertise, if it even exists, to make a guarantee that someone who has been assessed for rehabilitation over a period of years, incarcerated in a controlled environment, that will translate out into the public. It's just a guess. This and all of the other bills to promote leniency seem to be just a huge social science experiment of let's do it and see what happens. Why they're focusing on the worst of the worst, I don't know. I have not had an explanation for that. Why not, if you want to provide some sort of leniency, start with the bottom level of crimes, the nonviolent crimes.
Did you want to talk about the perpetrator? Or
I will. I'll tell you about my own experience. And the reason I'm having a panic attack is because my son and a female friend were brutally, violently stabbed to death in 2017. He's in prison for life right now. That was a promise made to the family and friends of my son and his friend. We also have the truth in sentencing that says he must serve up to the minimum of his sentence, which is life. Those things all seem to be at risk right now. If you take that away, then he will be subject to what the people behind me are discussing, which is literally, they've just told me, he could apply to be resentenced at 10 years. He's been in there for 6 years now. I'm frankly disgusted that we, the victims or co-victims, are constantly made to feel that, I guess you could call it, gaslighting. We're made to feel that apparently what happened to our loved ones was really not all that important. Otherwise, why would you be wanting leniency for the perpetrator or for the offender? We're made to feel like we are inhumane because we don't want the offenders to have a chance at a better life. So I'm going to tell you, I don't have a problem with rehabilitation within the prison system. I don't mind if what they do, as long as they don't open the door and let them out. I want my son's killer kept in prison for life. What he does while he's in there, what programs are available to him, so be it. That's my compromise. Draw the line at violent crime and murder. Let us co-victims have a voice. Stop re-victimizing us. Stop re-traumatizing us. Spend your time trying to figure out ways to prevent the violence in the first place, instead of coming along now trying to put Band-Aids on cancer, trying to fix the lives of killers and violent offenders. I'm sorry, I guess.
Tanisha, did you want to? This is Tanisha. She's a victim and has been a voice now for victims, I believe, in the mid-Michigan area. Wants to share her perspective, so please.
Hello, I am Tanisha Ashakur, and I am the CEO and founder of an organization, a nonprofit called Voices of Color, and we believe in being the voice for the voiceless. So in particular with these bills, again, I would like to say I don't have any issue with rehabilitation. My primary issue is that oftentimes when we look at or consider violent offenders, we often negate that being those who perpetrators who have committed crimes of domestic violence. I would first like to reiterate that also in the state of Michigan, most perpetrators are in prison now, but not for domestic violence, and they have had several domestic violence calls. They probably have police records of several calls to homes where they have committed crimes against their intimate partner, but they're not incarcerated for domestic violence. In particular, I have, with several cases that I've seen, we're talking about providing so many resources for those who have been incarcerated, who've had an opportunity to be productive citizens. And yet we don't offer those same services to victims and survivors in our state. So that is my issue when we are constantly cutting budgets and not even bills going through for victims and survivors of domestic violence. So we can't provide those resources. So when we're talking about early release and not considering those who are abusers, we haven't factored in the fact that they're going to be coming back into a community where victims and survivors are now in the process of healing, and that could be years, and you're releasing them, and the victims and survivors don't have the resources to continue to protect themselves. Not only most in the mindset when we say victims and survivors, we're thinking about adults who are possibly have the capacity to take care of themselves in an economy that is decreasing when we're talking about like living expenses. We haven't factored in victims when we think about their children. I get emotional thinking about that because we know that after a victim tries to leave their perpetrator, their abuser, there is a 75% increase in the possibility of a homicide within 2 weeks. So even if they have been, in this case of like Nicole Beverly, they sit and they fester. They are mass manipulators. They are narcissists. And so they are very capable of working a program to a T to do exactly what they need to do to be released. And we have seen in several cases, one where a abuser has gotten out, and she relocated her entire life to Florida. He got out and he went to Florida. He murdered her. And so when we begin to talk about these bills and we don't even ask the victims, more than likely because they don't have the resources, they don't have the capacity to get off work today to be here because all of their PTO time has been used so they can keep going to court. All of their PTO time is being taken up because family court has failed to protect them and their children. CPS, oftentimes, many of you may not realize, is that they oftentimes put, regardless of the say, and I want to make sure we understand domestic violence abusers can be male or female. In the case with CPS, when there is involved in these, you let a perpetrator out. The state of Michigan has often forced victims to still continue to allow their abusers to see the children. We've had cases where they have literally been left for dead, and it was by the grace of God that they survived. I'm saying, talked about shot and stabbed several times, and they are, to this day, they have not received a trial, and they are being forced to still allow their abusers to see the children. So when we begin to think about releasing and not considering those who are perpetrators, abusers, we can't even begin. And then I think there's a part where it talks about risk needs assessments. That is very subjective because we know a lot of times people who are completing the risk needs assessments, they don't even have the proper training to probably even be doing the risk needs assessments, nor have we even begun to think about lethality assessments. So from the beginning, now we're almost processing something at the very end, talking about releasing someone that's for domestic violence crimes. And it started from the beginning when a police report wasn't even properly reported or they were not even properly charged. And so now we're going to release them because they violated let's just say they violated probation or parole. Now they go back and they're incarcerated. Really what actually happened is at their home, there was a domestic violence offense committed, but they were not charged with that. So when we begin to think about that, there's a totality of circumstances that haven't been considered. And our major thing is when we're looking at domestic violence, we cannot exclude perpetrators of domestic violence, those who have been abusive. And abuse is a personal choice. Nothing contributes to that. It is a personal choice. So for when we talk about recidivism and it being higher, we haven't even began to decipher the many levels that it comes to that someone's going to have to begin to undertake by that release because there are systems that are not already protecting a victim and survivor. So thank you so much.
We have Rayvon Fields here who'd like to say a couple words, and she's a voice for domestic violence victims and a victim herself. So.
Hi, my name is Rayvon Fields, and I am a survivor, and I also volunteer for Nicole Beverly's organization, the Enough Initiative. This bill is kind of hard for me because I come from two sides of the fence. I have a brother who is currently incarcerated, and he was sentenced to 10 years, and I miss him and would love for him to be able to come home. Though I understand his conduct has not been great in prison, and I honestly don't believe he earns the right to come home even after his 10 years. And so for myself and thinking of other victims who are facing this fear of their perpetrators being released from prison, one thing that really speaks out to me and stands out is that in my county, in Washtenaw County, for example, if there were perpetrators that were released from prison back into Washtenaw County, right now our shelter in the county, Safe House, is not accepting victims. They are only housing a few victims at a time, if that, meaning 3 to 5 at most. And so it's very frightening to think that people will possibly get out and there is not even a safe shelter or a safe place for victims to go if they do need that resource. And so hopefully this will open up the minds of some more people to really reconsider these bills and to think about us and the victims and how we feel regarding this as well. Thank you.
State Representative Mike Harris, who served 26 years in law enforcement, would like to sort of give the opinion of a law enforcement, of a cop, someone who's been on the ground floor at least. So, Representative.
So I spent 26 years in law enforcement in the Oakland County area, and we have two other career law enforcement officers in the room with us, Representative Bagol and Representative Bazat, who spent probably more years than what I did. Between the three of us, we've held the hands of countless victims, probably thousands between the three of us. All this does, it's a continuous slap in the face, these packages of bills that we've seen come down, not only to the victims, but to law enforcement and the criminal justice community as a whole. We're not here talking about the rehabilitation side of prison. We're here talking about giving the offenders second chances while we're not giving the victims second chances. So, and I think the focus really needs to be put on the victims in this. I still talk to victims in my community. That's a passion for me. And until we start putting them as the priority here in the state legislature, we're going to have a serious problem. And, we focused, and I think Rep. Filler and Leader Hall have both mentioned, our prison population used to be up in the 50,000 mark, and we've reduced it greatly. And I give that credit not only to law enforcement, but some of the rehabilitative process that we've had in prisons that have kept people from coming back. But we should not be rewarding the people that have now victimized our communities and send them back to the streets to continue doing that. So that's my perspective on it, and I'd be happy to answer questions later. So thank you.
All right, so that's everyone's testifying, and we're happy to take a couple questions. And if you'd like to speak to anybody, I believe everyone's available afterwards. So, okay, thank you so much. Oh, Beth, go ahead.
So Michigan Supreme Court in the past, like on juvenile lifer issues or on other sentencing issues, when the legislatures failed to act, they've stepped in and said, yeah, you got to resentence these people. Is there a fear that if the legislature doesn't act in these circumstances, a case could come up where they make this decision?
So I will just tell you, juvenile life without parole is a great example where individuals are being resentenced across the state of Michigan. And so I feel like the court system is working. So when we were here 2 weeks ago talking about, hey, individuals are being resentenced. Sometimes they're being released if they've been in prison for a long time. And the sentencing judge said, okay, this individual's rehabilitated. Sometimes they get a term of years because of the seriousness of the sentence. Sometimes they get life they get life in prison. But that process is working. And so I don't know why we would try to fix something at the expense of the victims and of public safety for a system that's clearly working on considering all the factors, considering the heinous of the crime, the rehabilitation elements. So I believe that the legislature can be part of this solution, but if something's working, like the juvenile life without parole, I'm not sure why we would take steps to further allow individuals like an Ethan Crumbley access to get out quicker.
But it seems like the Supreme Court case moving the benchmark lower in terms of who gets resentenced. So do you feel like if the legislature doesn't act on this, they're going to take it into their own hands?
I mean, and sometimes we just disagree with what the courts do. So I know the courts are probably eventually going to say that 19 is a juvenile murderer. I disagree with that. 18 is the clear line that we set. We set it for raise the age, but that'll be the court deciding that. And if that bill came up, I would vote against that bill. And I presume that most of us would vote against that bill too. So unfortunately, our role right now is to say that this legislation is bad for the public safety and victims in the state of Michigan. And the court's going to, take up cases as they come through.
So I'll just say, in the U.S. Supreme Court case, right, those were minors that committed offenses. And they said that they were not entitled to automatic life, so they had to go through a resentencing process. Some were resentenced to life. Some were resentenced to less time. Some were let out. What we're talking about is every person, adults, and the crimes they commit. And so I'll just say, first of all, I don't see a threat that the courts are going to come in and say, if an adult commits first-degree murder,
That's right.
They cannot be sentenced to life. Some states still have the death penalty, right? So in some states, those first degree murders get the death penalty. In Michigan, they get life. What this will do is this will say after 10 years of time served, they're eligible for a hearing to get resentenced and to get out of prison. I do not see any, I've not seen anything that suggests that a court would order states to do that. I'll just point out one more thing. So in this legislation, if the prosecutor files the petition and the court sides with the prosecutor, then the maximum sentence is what the prosecutor recommends. It could be less, but the maximum would be what the prosecutor recommends. So if you look here, like in Ingham County, you know, your last prosecutor was pretty radical, and we saw the consequences of that with the Michigan State shooting. But you could have a prosecutor who puts all these people behind bars, and then the next prosecutor comes in after them as one of these woke activist prosecutors who comes in and says, I don't think anyone that committed this crime should serve this sentence. And so they could come in and petition to significantly lower those sentences, and then the judge would be forced, if it met the conditions, to then award that sentence or less. So this is sort of a way for these more liberal woke prosecutors to come in and start undermining the judicial system. So I think I didn't mention that earlier, but that's a particularly concerning principle of this legislation.
Okay. Yeah, go ahead.
So if the court system is working, this bill is saying, these criminals will be eligible for a second chance, right? A second look, but it's not to guarantee that they get out of jail free card, right?
That's right.
So I guess, like, where would that risk be if the ultimate decision is still made by a sentencing judge, not the prosecutor?
So it's a great question, because when an individual goes through sentencing, everything is considered. And then you get a minimum and maximum, and a judge can go lower, a judge can depart, and then you even go through an appeals process. So there's a very active process at the sentencing. The crimes that we're talking about on the higher end that we're really concerned about, murder, attempted murder, criminal sexual conduct first and second. I think the judge and the victims and everyone is very aware of what happened when that case comes through. There was a rape. The judge has decided our society has decided that's an incredibly dangerous thing. That individual needs to go away for 25 years. Let's call it on the minimum. The process that, every criminal, no matter the sentence, 10 years gets a re-review. First of all, I'm not even sure how the court system could handle that right off the bat, because that'd be something like, if I'm in prison for an extended period of time, it's not like I'm maybe doing a whole lot. I'm going to raise my hand and say, I want a re-review. And if I don't get it quick enough, I'm saying there's legislation that says I get it, I'm probably going to file suit. And so first of all, this is going to be a massive burden on the courts. But the second of all, the court has decided, and the people of the state of Michigan, giving the court and the judge discretion, has decided that CSC 1 is a really serious thing, and 25 is the minimum, and they're going to serve that. And if you say every time 10 years, you're really going after the victim then, and you're really going to war with the victim when it comes to a re-victimization and a rehearing and lack of time for healing for that victim. So I would argue that it is completely unnecessary, and in fact goes much too far.
And I'll just add, just real quick. So far, the time I've been here, this conversation has been about the criminals. And so what we were trying to do today is to show, and this is one of many examples that we'll show you, the faces of the victims, right? The victims are not always listened to or thought about in these conversations. And you can see from the testimony today the pain that many of these people still have from these acts that occurred, and the sentences that these perpetrators were given, these criminals, are part of that healing process and that comfort that these victims and their families have. And so when these things are under threat every 2 years potentially, as they're eligible to refile for these new hearings to get lower sentences, That's putting these victims through that every 2 years, potentially.
Yeah, go ahead.
Could you speak more to the immunocompromised loophole, fast pass?
Yeah, I'm going to do my best on this one because this is relatively new legislation. But essentially, if an individual was eligible under the second look or second chance or whatever we're calling it piece of legislation, and they had if the incarcerated individual has one or more medical condition that make them more likely to contract an illness or disease, then essentially the presumption is they get a quicker hearing and they should get out. The presumption is that they should be released. And I'm happy to share the specific language with you. But the fact that that would be a key aspect, right now we have something called medically frail in the state of Michigan, which if a prisoner is deemed to be medically frail, they can be released. This is like the bedridden 70-year-old. I'm happy to talk about that because those individuals do cost the state of Michigan a lot of money and they may clearly be on their deathbed. But this takes that and supercharges it to give a presumption that if they have any health issue, that they should be let out.
Just to expand on that. So this could be a cardiovascular disease. This could be asthma. This could be diabetes, hepatitis C. And it says not limited to. So other things, like I remember during the pandemic, if you had obesity, you were at a higher risk. Those would be things the court would have to determine one way or the other. So you could argue that, but these are specifically listed conditions. If you have one of these conditions like asthma, then what would happen is you get a quick hearing within 45 days. And then the presumption would be that you get out on time served. Then the prosecution has to go and make a case that that they have to prove why they should stay in. So if you don't have one of these conditions, then it's a preponderance of the evidence standard. So that's like a 51% standard to let them out. If they have one of these conditions, that burden shifts where it's the prosecution then that's in the position where they have to prove why they should stay in more than time served. And in that case, the judge would still have to determine that that there was, this meets the interests of justice and all these things that are kind of terms that are out there, subject to interpretation.
I would just like to share that the man who tried to hire 5 people to kill myself and my children would qualify, as he does have asthma. So that would give him a much quicker opportunity for release.
Yeah, Beth.
Okay, just one last question.
Sure.
You guys were around when they passed Clean Slate, raise the age, stuff like that.
Got to lead on it.
Right. And with these recent packages, where do you think the line is between leniency and kind of mercy towards youth or towards prisoners, and where it departs into no, this isn't accepted?
I just want to tell you, like when I worked on expungement reform, I sat in a room with groups from everywhere, from law enforcement, social justice groups, the defense attorneys, and I said, what makes sense when it comes to giving people more freedom but not hurting the public safety and not re-victimizing others? And it came out. I got support from both sides regarding expungement. Victims community didn't think it was damaging. The most serious crimes were not included in auto, and you can't petition for them either. So I felt like that was a good example of a reform or an improvement to the system that frees up individuals in the state of Michigan, but doesn't re-victimize and doesn't harm the public safety. Raise the age makes sense. As a 18 years old, this is what we do, is when you turn 18, you become legally an adult. We had a justice system that presumed 17 to be an adult. Well, that's not what we do, right? But that doesn't somehow re-victimize, and it doesn't have the victims community standing up and say, I feel unsafe. And so all I know about these bills is that these are not being drafted with victims in mind. They're not being drafted with victims and law enforcement in the room, or people who make their career on public safety. This is being drafted by individuals who just feel like we need to get really violent people out of prison. And so that's, if I'm not in those rooms and the victims aren't in those rooms helping draft and helping support, then I'm not going to stand with them. Yeah, go ahead.
Is there a risk, I guess, to the perpetrators here that in the event of a resentencing or rehearing, the defense could come back and provide more evidence and they could be resentenced without a harder sentence, or is it your original sentence or lighter?
I mean, I just want to tell you, I can't imagine that happening. The juvenile life without parole process is actually a really good one to discuss because I feel like it's been pretty straightforward, where the judge will look at all the evidence. Typically, there's not new evidence after 10, 20, 30 years, and the judge makes a recommendation. And some of those judges have said that individual has served their time. They have rehabilitated in my eyes, and I don't believe they're a danger to the public. And sometimes the judge has said that person really did a horrendous thing and murdered a couple people, and they need to serve their time. So I feel like that's a good example of the justice system working. I can't imagine in the resentencing, and I can tell you that the people who drafted this bill are not thinking of that when they're thinking about this bill. They're thinking about lower sentence. Everything in this bill is slanted towards pro offender, pro murder, pro CSC, essentially pro prisoner. And so that's what they're drafted in mind, reading them. As you go through and you say, what does asthma have to do with whether an individual is still a danger to the public? Okay. Actually, finish. I'm about to tell.
Okay.
Okay. And again, if you'd you got a question? Yeah, go ahead.
Nobody else does. So what would get the Republicans on board? I mean, would, with the productivity credit and second look legislation, would you guys then be okay with excluding some of the most, dangerous, as you said, crimes like murder, homosexual assault, all these things?
So no, I think the answer would be no. And it's a two-part question because you mentioned productivity credits and you mentioned the second look. Truth in sentencing is really popular in the victims community, in the law enforcement community, and I would say in our caucus, because we believe that there needs to be accountability and there needs to be time for the victim to heal, and that truth in sentencing provides that. So I don't think just taking out assaultive crimes, which by the way would be approximately like 80% of the people in prison, but I don't think that would gain support from our caucus. And the second thing you asked about second look, and we just view that as not just a bureaucratic burden, but also really damaging to the thousands and thousands of victims who will then find out that the individual who committed a very serious crime is going to be up. So I don't think that would move the needle.
And just to say, there's nothing that prohibits the legislature from looking at an individual sentence, and we do that from time to time, looking at a criminal sentence and saying it should be increased or decreased. So I think you could see Republicans get behind proposals on specific crimes to say, this compared to this is not right. It should be lowered or raised.
Right. Just last year, we worked on fentanyl, raising the penalties for manufacturing and distributing fentanyl, lowering the penalties for something like ecstasy or marijuana. And we're going to try that again because that's something that we clearly understand to be a change in culture and the law and how we understand the properties of fentanyl and marijuana. And so we have that right all the time, and we do it sometimes.
Yeah, these are though blanket proposals that would, if it's a 10 to 20 year sentence, you could get 8. And then in this case, if it's 10 to 20, or say it's life without parole, after 10, the judge can undercut it. So, again, if there's a need to look at specific sentences, you can get us on board, but you're not going to get us on board with these blanket ideas of just letting everyone out early and giving them opportunity after opportunity and an opportunity to be let out early, especially these violent criminals and people that committed criminal sexual conduct.
Okay. And everybody's available for questions back here. Thank you so much for coming today. Thank you.
This is all your.